The Honorable, the Supreme Court.
Good afternoon, everybody. Thank you very much. Please be seated. Please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled WWSAF Special Partners Group LLC et al. Versus Costello, Valente, and Gentry PC et al. Case number 24 AP 168. Representing the appellants Costello, Valente, and Gentry PC and James Valente is Attorney Laura Devine. Seated at counsel table with Attorney Devine are Attorneys Thomas Costello and Victoria Taravella. Representing the appellees and cross appellants, Gravel and Shea PC and WWSAF Special Partners Group LLC is Attorney Matthew Byrne.
Okay, thank you very much. Good afternoon again. We'll hear from counsel for the appellant. Come on up, please. And for the record, introduce yourself, identify your client, and then proceed.
Good afternoon, Your Honors. Laura Devine of Boyle Shaughnessy on behalf of Costello, Valente, and Gentry. May it please the court. My name is Laura Devine, and I'm here on behalf of Costello, Valente, and Gentry, or CVG. We ask this court today to reverse the trial court's judgment and to enter final judgment in favor of CVG. This case is about fairness and a radical change that would impact Vermont practice. The trial court erred when it concluded that CVG was unjustly enriched and when it applied the common fund doctrine to permit Gravel to recover attorney's fees from CVG.
So, Ms. Devine, do you think we should not recognize the common fund doctrine or that it shouldn't be applied in this case?
It should not be applied to this case.
We have recognized that it's available.
So the common fund doctrine, as I understand it, Your Honor, was recognized for the first time in Gale versus Allstate, which was an order of this court, a ruling from this court from April 2000, 25 years ago. And
this case is significantly different than Gale, is it not?
Yes. Yes. So it's our position that this case is significantly different and that when this court in Gale recognized that the common fund does apply in Vermont, this court recognized that it was under appropriate circumstances. And it's our position that those circumstances are not present in this case.
One of those being that in the Gale case, the parties that shared the so-called common fund were not opposing each other, right? Which is a lot different than the situation here.
Yes, that is one of the distinctions. And another distinction that I think is very important in terms of Vermont practice is that concerned subrogation. And Gale, it's Gale versus Allstate. Gale was the insured and Allstate was her insurer. And it involved subrogating and obtaining in subrogation monies for Allstate. And the ruling was that Allstate had to pay its proportionate share of attorney's fees to recover that sum.
So wouldn't the analysis in this case be that if Gravel and Shea provided additional funds for Costello Valente's client by their actions in getting Lloyd's of London involved in the case, increasing the value of the case from X to Y, wouldn't that be the same type of analysis that Gale had?
So we disagree with that, and we think that it is a different analysis. And the primary reason that it's a different analysis is that this is a case where the attorneys involved, Gravel and CVG, were not representing the same client or a client that had the interests were not parallel, and they diverged enough and they were distinct enough that the reasoning applicable in Gale should not apply here.
But it's an equitable determination, is it not?
It's an equitable determination, and the ruling of this court was that it applies in appropriate circumstances. And the appropriate circumstances in Gale the way that the decision and the way that the holding is crafted is that it's very narrow to apply as to what transpired in the case of Giel. Prior to that, this court had declined to recognize the common fund at all in the Robes versus the town of Hartford case. And in Giel, they determined that it does apply. It applies in certain situations, which we contend is not present here.
And if we,
I'm sorry, in Giel, didn't we also say that there was an intention to create a common fund to benefit more than one party?
I believe so. I believe that it was the intention to create the common fund. And which in Giel, the underlying relationship between Giel and her insurer, there's a policy of insurance that governs that and that dictates the right and recovery of subrogation, where Giel, having taken action and procured that subrogated right, ultimately owed, because she recovered the money from the insurance company for the insurance company, and the insurance company got it. The insurance company was on the hook to pay for it. They were on the hook to pay for the fees that got the proportionate share of attorney's fees that got them there.
I'd like to ask you a question and follow up to John Cohen's point about bringing money into the case. So I want to give you a hypothetical because I'm not sure where the boundaries are of what he's asking. Plaintiff sues a defendant for an accident. The defendant makes a third-party claim against someone, and that third party wants to participate in the settlement of the claim by contributing, say, $50,000 into the settlement pot. Under his theory, would there be a common fund that could be accessed?
So it's a very good point and question that you bring up, because in any matter where there's indemnification, like a third party claim being asserted, the ultimate beneficiary is always the plaintiff. The plaintiff is the beneficiary, but that doesn't mean that in Vermont, the plaintiff has to pay for a proportionate share of attorney's fees to bring that result, to bring that party in.
That was my question.
Did CVG during this process benefit Gravel and Shea and their client at all?
So that's an interesting and somewhat complicated question. CVG's client was Mr. Flay, who fell off a roof and was injured. Gravel's client was the employer that did not have workers' compensation insurance, the roofing company. On behalf of their client, CVG worked to identify how their client could recover in those circumstances, including in that circumstance, they would be eligible for a tort recovery instead of an workers' compensation recovery, because there was no workers' compensation insurance. But under the statute that applies to workers' compensation, the owner of Walker, who was Mr. Sisto, would have faced personal liability for any judgment in tort. And that's where there's a significant situation, which I guess could be construed as a benefit to Walker, where Sisto was not pursued.
Did Fales benefit Gravel and Shea by signing the agreement with Lloyd's that said he would drop his cases against Walker?
So in doing that, I would say that Mr. Flay benefited Walker because Walker was the party that was being sued and they were no longer being sued. The tricky question in this case is that Gravel and Shea had a contingency fee agreement where they were representing Walker. And when the case was dismissed, Gravel and Shea, the value that they had in where they had viewed the case decreased significantly because they were looking at a smaller portion of losses. They were looking at specifically the amounts that were paid out to Mr. Fillet under the workers' compensation order, even though there was no comp insurance. There were some monies that had been paid out.
But wasn't a question involving collectability of any judgment against Walker?
So, and that was one of the issues in the underlying case, was whether it was collectible. And, it's the position of CVG and the representation of their client that Gravel was doing everything they could to minimize the risk for their own client by selling off all of their assets and making that was something of their own creation, that it was uncollectible.
But it was a question before there was coverage ever secured, on whether or not any judgment against Walker would be collectible because of the way he was manipulating or what he was doing with some of his assets.
Correct.
But the difference here between this case and Giel is that here, every dollar that is being raised by Gravel and Shea, arguably, if they're responsible for the money being put on the table, is going to discharge an obligation that they owe to the injured party. And that's not the case in Giel.
Correct. So with Gravel, and in this case, Gravel was paid. They were paid out of that smaller figure that was obtained by Cornerstone relative to the losses that were paid out already to Mr. Fillet. So both attorneys were paid. What this case is about it's about Gravel's attempt to get a second payday, and to get a second payday through a mechanism of unjust enrichment, which we do not think as a matter of law is appropriate in this case. I do wish to reserve some of my time for the rebuttal.
Yep. That's fine. No, don't see any questions.
Okay.
All right, thank you.
Yep, I'll reserve my time. Thank you.
So we'll hear from counsel for the appellee. Please come on up and, for the record, introduce yourself and identify your client.
Good afternoon. May it please the court. I'm Matt Byrne from Gravel and Shea on behalf of Gravel and Shea. Wanted to start by answering some of the questions that were posed here. One of the questions was getting to the issue of opposing interest in the case. And the common fund doctrine has been applied in many cases where they're opposing interests. And we cite a number of them in our briefs. Those relate to objectors in class action situations. And the cases are In re Southwest, Arkansas Teacher, and Park versus Thompson Corporation. So the idea that there may be some competing interest in a case is not sufficient to defeat the common fund doctrine. There was also a question about what the intention was in creating it. And I just want to read a paragraph from Jerry O'Neill's affidavit that gets to the intention of the case. And he said, upon learning that it had no workers' compensation coverage, Walker retained Gravel and Shea and brought claims against Cornerstone and Wassell in Wyndham Superior Court to recover the monies needed to compensate Fales for his injuries. That's why we brought the case. That's why Gravel and Shea did it. And I can tell you, knowing Jerry, that's exactly his primary motivation in bringing this case. He worked his whole life to recover for victims of injuries. And, Walker may or may not have had assets, but I can tell you Jerry's primary motivation was to find money for somebody who had been injured.
So, Mr. Byrne, before you proceed, I just have a question in terms of the settlement between Walker and Cornerstone. So your firm received the fees from that settlement. So why is that not full compensation from others within the scope of the restatement? Section 29 of restitution.
Thank you. The reason is that the benefit, when you measure full compensation, you look at the benefit conferred. And in this case, there's no question, there's no dispute about the amount of benefit that Gravel and Shea conferred on the Costello firm, which is how we're, analyzing the unjust enrichment case here. And that benefit is set forth in our brief, and it's actually set forth in the court's opinion. There was increased damages of $653,480.80, and then there was also another increased damages of $243,770.06. And you can see that at special case 14 and 15 and the special printed case 14 at paragraph 12. It also appears in the Superior Court's opinion that analyzes how much the benefit was increased. So the smaller settlement that occurred is not really relevant to the issue under the restatement, which analyzes what the benefit conferred was. What it really is how much more we increased the settlement because of the actions that Jerry took and that Ms. Mensch took in bringing more expertise to the workers' compensation.
I'd like to know how you define benefit, or incidental benefit. It seems to me that your firm, when it brought Lloyd's into the case, is it Lloyd's or Lord's?
It's Lloyd's of London.
Whatever. When they brought that insurer into the case,
Yes.
Gravel, I would think, was doing that for its own client. And so when does it become a benefit to somebody else, in this case CVG, when Gravel and Shea was bringing that insurance company in for purposes of assisting their client with the payment they might have to make?
Well, I think I disagree with the premise, and that gets back to paragraph 22 that I read from Jerry's affidavit. The reason that Jerry brought Lloyd's in was to get compensation for Mr. Fales. Essentially, and I don't think it's disputed, Walker's judgment proof in this case. So if there's a case against Walker, there's really going to be no collection.
Right, but nonetheless, that being said, there was a release.
There was a release executed after they entered into the settlement agreement with Lloyd's. Wasn't something that Walker procured, they just executed it.
But I'm gonna ask the same question again. How do you define a benefit? I mean, what I worry about in this case is it seemed that the two law firms here were communicating with each other and sort of working together, giving each other documents. I don't want to discourage that by making law firms or attorneys not want to corroborate with opposing attorneys for fear that they're going to have to give up some of their attorney's fees if some benefit was given to them. And you know, an example is if an attorney has a argument here and knows that another attorney wrote a brief about it a while back that was successful and asked for the brief to use in writing his or her own brief, is that a benefit? I mean, is that attorney who gave the brief that they wrote gonna say, I get part of your attorney's fees because you won because I gave you my brief?
Yeah, I don't think that's gonna, that's a case by case determination. And I think the facts.
That's why I'm trying to figure out how we're gonna define it.
Well, in this case, it's pretty clear because the benefit conferred is the amount of the settlement that was increased by the work on the experts. Because they went up by a set amount that is set forth in the testimony of Ms. Mensch and also set forth in what Judge Tor found at trial. So that's not really an item of dispute, but the bigger problem that you're talking about, where and when do you have other cases? And the best answer I can give you is that it's going to be a case by case analysis in each specific case to see whether the benefit conferred is sufficient to create a common fund.
So what is a benefit?
In this particular case, the benefit is the amount of attorney's fees that the Costello firm got as a result of Gravel and Shea's efforts. Like in your case with the brief, it's not exactly clear, right? You can't really isolate how much that brief helped them to, win their argument.
Would this CVG's client go and make a settlement without even telling CVG that? Is that right?
No, that's incorrect.
No, I thought that
I think that's in the record.
he made a settlement with them without consulting with the law firm.
No, I believe the law firm was involved in the settlement. the law firm was involved in putting the settlement together. If you want to look, you can look through the affidavit of Jerry O'Neill, and you can also look at the testimony of Mr. Valente at trial. They were involved specifically in creating the settlement. The party that wasn't involved was Jerry O'Neill and Gravel and Shea. They cut us out after the mediation. So the mediation occurred, then the Costello firm went out and settled the case out from underneath Gravel and Shea. So Costello firm was involved in the settlement the whole entire way. They just cut Gravel and Shea out.
I appreciate your comment that you are saying that this needs to be analyzed on a case-by-case basis. I want to go back to Justice Cohen's question. Is it as simple as value added, which, for example, you bring a third-party defendant into the case and there's a settlement and they contributed 50 grand to the settlement? Is that enough to have a common fund? Because they wouldn't have been in the case if you hadn't claimed over against them.
Yeah, I don't think it's quite that simple, but that is an important factor in determining it. I think you also have to look at whether you put effort into doing it, right? What you did, what your legal work was that resulted in the settlement occurring. In this case, Gravel and Shea defeated a motion to dismiss and a motion for summary judgment against Lloyds for London in the case where Lloyds for London was trying to avoid liability. Had it not done those two things, Lloyds would have been out.
Well, Gravel and Shea was trying to avoid liability on behalf of their client as well, not you personally, not the firm, but the firm's client.
Well, there was no liability in the Lloyds case, right? The Lloyds case is just a breach of contract to procure insurance.
Right, but those monies that were coming from Lloyd were also discharging your client from the case.
Not necessarily, because as they said in their testimony, they still could have proceeded against us, right? They could have. They took the voluntary action of discharging us, right? But they still could have proceeded to us, notwithstanding the fact that there was $1 million or however much in the settlement. So they could have, but the way they structured the settlement through their own voluntary actions was to have an issue or release. The other point, though, is that may be true for Walker, but it's certainly not true for Gravel and Shea, right? We had no liability at all. We had absolutely no obligations to anybody. And the work that we did is what resulted in the settlement. So there was no corresponding benefit over to Gravel and Shea from anything that the Costello firm did.
So then, Mr. Byrne, under your analysis there, who in your mind is the intended beneficiary from the fund then?
Well, it's two people, right? It's both.
It's Walker and Mr. Fowles?
Well, the intended beneficiary from the fund that was created from the Lloyds case fails, and then the Costello firm, because they had a contingency fee agreement. So they were an intended beneficiary for the work that they performed.
And then you also had a contingency fee too, correct?
That's correct.
Okay. And so, and you did get paid between the settlement between Walker and Cornerstone.
There was a small amount of money that Gravel and Shea did receive.
Okay, and from your perspective, then that is not the full compensation.
Correct. I think the way the court should look at it is potentially a credit to the recovery. And you look at the overall benefit conferred and what the contribution was to it. And then you may give a credit at the end for however many fees were collected in the small settlement act.
Thank you.
So, Mr. Byrne, is the theory that the actions of Gravel and Shea created a larger settlement value that was available to CVG's client,
Correct.
and that you're entitled to a portion of that? Is
Correct.
that the basis of the?
That's correct. Yeah.
And you've also had a cross appeal saying that you're entitled to $299,000. And can you give me the basis for that?
Sure. The cross appeal was actually from the court made a mistake in saying we didn't object to the purple highlighting in the exhibit that they filed, which took our fees down from roughly 227 down to 72,000. And our cross appeal was mainly, the court never admitted that into evidence. That never occurred. And in addition to that, there was no evidence supporting the purple highlighting. And finally, the court said we didn't object to the exhibit, but that's completely shown in our proposed findings of fact and conclusions of law that we provided the court. And I can't explain why, but it appears that the Superior Court didn't even look at those, because her legal conclusion was that we had waived it, right? She said, Judge Torres said we didn't contest it at all, but that's just not true from the record, because there are 8 or 9 paragraphs from our proposed findings where we did go and say this exhibit is unsupported by the evidence. There's no reason for having it in the record. And the trial record also shows that we objected to its admissibility, and the court never admitted it into evidence. So that's what the cross appeals have.
But it's an equitable determination. How's that in any way equitable for you to get the entire fee?
Well, we're
And-
not.
What's that?
We are not getting the entire fee.
You're not getting, I'm sorry, I can't, I'm,
We are not getting the entire fee.
well, a pretty good chunk of it if you get if your cross appeal was to be granted.
That is true. But that's related to the amount that we increased the settlement by. It's just from the numbers, right? It's a straight calculation. It's, it's a third of what we increased it by, because we did increase it by a lot. And so that's the reason why the numbers are so large. But what's also really interesting about this is that's exactly the methodology that the Costello firm said you should use. In their reply brief in the Superior Court, they said, don't look at the time that Gravel and Shea put into the matter, look at how much they increased the settlement, right? This is the methodology that they suggested. And we just said, okay, that's great, let's use that. And so, on the appellate record, when you review it under the doctrine of invited error. And under invited error, they can't really contest what they proposed to this court.
How can you prove how much you increased the settlement by?
We had testimony both from Ms. Mensch on the stand, who detailed her efforts to increase the expert report and the amounts that the damages went up, but we also.
But how do we know that Lloyd's relied on that report when settling with Vales?
Because of the uncontested testimony from an exhibit that they offered into evidence, which was the affidavit of Mr. Jerry O'Neill. He says that paragraphs 47 and 48 in conclusion of other paragraphs that describe the facts surrounding it, it says, but for plaintiff's efforts in bringing the case against Cornerstone and defeating motions to dismiss in summary judgment, Lloyd's would not have paid Vales, and therefore Costello and Valente anything.
Right, but that's kind of an overbroad statement. So how do we know that Lloyd's ever even considered that report? Or
But for a couple of things, it's all the things leading up to it in the paragraphs before that statement, but it's also the behavior, right? They didn't go to mediation until we beat back those motions to dismiss and motions for summary judgment. So it's the only evidence in the record, and the court should, and it's uncontested. So the court should accept that evidence as the evidence of causation in this case.
You admit that you took some steps as Gravel and Shea that were contrary to the steps that wanted to be taken by CVG. For example, consolidation, continuance.
Oh, in the other case, yes. There were, well, I don't know if they were contrary, but they were actions taken in the interest of our client.
Right, but CVG opposed those.
They did, but we don't necessarily agree that that was the right thing to do to get money for their client. We thought that the way that we approached the case was the best way to get money to Mr. Vales as quickly as possible.
Okay. Time
Thank
is
you,
up. Thank you very much. How much does the appellant have, please?
Appellant has 3 minutes and 54 seconds remaining.
Counsel?
In this case, CVG represented Mr. Flay and Gravel represented Walker and Sisto. Here, one of the questions has been, what would happen if Lloyd's wasn't in the case, if Cornerstone's insurer wasn't there? Well, if they weren't brought into the case, if they weren't able to be kept in the case, Costello, the CVG firm, would have gone after Mr. Sisto personally, which was permitted under the workers' compensation scheme. The record was developed in the trial court where Mr. Sisto faced substantial personal liability for the failure to have workers' compensation in place. That's significant because Mr. Sisto was represented by Gravel. Mr. Sisto's company, Walker, was represented by Gravel. Gravel represented both of them in all of the proceedings relating to Mr. Fillet's claim. The fact of the matter is that Gravel protected their client, Mr. Sisto, by bringing Lloyd's into the case, by bringing Cornerstone's carrier into the case to pay the judgment. They protected Mr. Sisto personally in his personal assets. They protected their client, Walker, by being their counsel while Walker disposed of the assets. We've heard that Walker was judgment proof. Walker was judgment proof. Walker had counsel that helped them and advocated for their interests. The rule in Vermont is that each party pays for their own attorney's fees, and that the attorneys shall bring the matter to resolution to a benefit for their client. The CVG law firm did that for Mr. Fillet here. They did the work. There was no unjust enrichment. They worked hard. They got a great result for their client. They negotiated a settlement agreement and they got a collectible sum. Gravel's firm also worked for their own client. They worked hard. They protected Mr. Sisto. They protected his assets. They protected Walker. This is the way that the practice is in Vermont right now, where attorneys represent their own clients. A change would be radical today if this court was to uphold the trial court, and this court would be asked on a case-by-case basis every time there was a dispute arising from indemnification claims, arising from different multiple defendants in litigation who are maybe contributing towards a settlement. Maybe they're making cost of defense reasons for contributing towards settlement. We don't know, but this court will be asked on a case-by-case basis whether they were unjustly enriched. The cases that Gravel relies on relating to parties having opposing goals, those one that stands out the most is the ones that involve class actions, where a class has been certified, which is a comprehensive process, and its objectors to settlements that were negotiated on behalf of the class. That's a common fund. What we have before the court and in the record today is not a common fund. It is substantially different and it's dispositive. We're asking the court to vacate the judgment and to enter judgment in favor of CVG, and that will keep the law in Vermont with respect to the common fund the same as it is today.
What do you say about the cross appeal for the additional funds that Gravel and Shea says they're entitled to?
So that was disputed throughout the evidentiary. That was disputed in the trial record. The methodology is disputed, and there's no evidence that anyone relied on that in order to reach the resolution that was achieved, including Lloyd's.
Your time has expired. Thank you very much. Thank you both. Please call the conclusion of the hearing.